Hello everyone, I'm Amy Coates. I'm an immigration attorney with Basham Spiro, and I'm here with our managing partner, Morali Basham. Basham & Spiro is a full-service immigration law firm located in Raleigh, North Carolina. We represent clients in all 50 states and around the world. Today we're going to talk about I601 waivers. We're going to split this webinar down into 3 different segments. Now, our second section in our webinar today is to discuss the actual legal standard for an I601 waiver. And there's 2 main things. First of all, an applicant for an I601 waiver has to have a qualifying relative, and there also has to be extreme hardship. For pretty much any case, it's always going to be your U.S. citizen or permanent resident, spouse, or parent. Sometimes a U.S. citizen or permanent resident child is also a qualifying relative, but not in most cases. So that's one, I don't want to call it a mistake or maybe a misunderstanding. People will often think that they can use their U.S. citizen child as a qualifying relative, but most times that child is not a qualifying relative for this type of case.
And what type of hardship are we speaking about here, Amy?
Well, we're talking about extreme hardship. But going back to the qualifying relatives, I also wanted to mention that a U.S. citizen fiancé is also a qualified relative. However, I don't recommend that a fiancé try to get a waiver for their, a U.S. citizen fiancé try to get a waiver for their fiancé. Because to me, if you're not married, it shows a lack of commitment. And I think it would be much more difficult for a consular officer to approve a waiver case if you're not married. The hardship standard is tough. I mean, it's definitely greater. I mean, any family member is going to suffer some degree of hardship if they're put into this situation. So it's got to go above that. It's got to go above an average level of hardship. And also, when you do one of these cases, you got to present the case in 2 ways. You have to talk about the extreme hardship that the U.S. citizen or permanent resident relative is going to face if they relocate to the foreign national's home country or to another country. You also have to talk about the extreme hardship that the U.S. citizen or permanent resident relative will face if they choose to stay in the U.S. without their relative. So now I kind of wanted to go through some of the things that I talk about when clients come in. When a client has made the decision that they're going to go for this, maybe they've made the decision or they're here and we have no choice. We have to file a waiver. But regardless, the first thing we do is we sit in and we have a brainstorming session. And we talk about every possible argument that might exist for their case. Now, some arguments hold much more weight than another. So when we go through these, it's not that in most cases, one of these factors is not going to be enough. Now, having said that, if you have leukemia, if you're a U.S. citizen and you have leukemia, and you absolutely need your foreign national spouse here to help you get to your doctor's appointments, and just to help you get around the house and do your daily activities, then that one thing is very, very extreme. That's probably going to be enough to win a case.
Or maybe even if the medical treatment you're receiving here is not available in the home country.
Oh yeah, that's true. That's true. So for maybe some sort of extreme health-related hardship, one thing might be enough. So the first thing I ask of the client to the U.S. citizen, to the permanent resident, do you have any illnesses? Do you have any physical disabilities? If someone is maybe 75, 80 years old, that might be something that we can use as well. Mental illness, emotional hardships, these are things that we always talk about. Different attorneys have different opinions on this one. My feeling is that I'm not a licensed counselor or a therapist, and I do not have the capability to assess whether or not my U.S. citizen or permanent resident client is going to have emotional issues and hardships that go beyond most any other person. So I ask them to go see a therapist usually. And see what the therapist or the professional says about that. I don't try to make that judgment.
I would think, though, if you were split up from your spouse, it would ultimately cause a significant amount of emotional hardship.
Right, but again, it's got to go beyond the hardship that any spouse is going to
So just missing somebody is not
No,
enough.
that's not going to be enough. Absolutely not. And also, if the U.S. citizen or one of the wife in the case is around the age of 33, 34, 35, 36, or even a little older, I definitely think that if the couple wants to have children, then that can be an issue as well. The next thing that I ask clients about are, do they have any relatives that they're responsible for caring for? If you have aging parents, if you have children you're responsible for, or children from another relationship where you know that the father or the mother of that child, that there's no way they're going to let the child relocate to another country. Those are all things that we can use. As far as miscellaneous arguments go, the U.S. citizen or the permanent resident's family ties to the United States. I recently had a very interesting case where the U.S. citizen, he lived within 1 to 2 miles of 6 brothers and sisters.
That's pretty amazing.
It is. So you know what I did? I got a map from Yahoo, and I plotted their addresses on the map, and I actually calculated the distances. And I don't know, but I want to believe that when the immigration officer saw that, that made it very concrete for that officer that this U.S. citizen, his entire family is here in the United States. And not only are they here, but they're very close. They all live within 2 miles of each other.
I've got a question for you, Amy. When you're trying to prove extreme hardship to who? Is it the U.S. citizen, is it the foreign national, or is it both?
It's the U.S. citizen or the permanent resident. It's not to the person who's applying for permanent resident status. I mean, I guess there are some arguments that can be made that if the U.S. citizen or the permanent resident sees their spouse in a difficult situation, that in turn that could cause them hardship.
Especially if a country condition is bad.
Right, exactly. If you know that your spouse is being sent back to somewhere that's just a horrible place to live right now, for sure. Okay, economic hardship. Financial hardship in and of itself is not going to be enough to win a case. If you're just trying to make the argument that you rely on your spouse's salary to pay the bills, I don't think that's going to work. But if you've got a mortgage, if you have school loans, if you have credit card debt, and maybe a car lease, lots of debts that you're responsible for, then I think, sure, those things can be used as well. Professional hardship, this one might be a little bit tricky. It really depends. If you have a demonstrated career path, in something that's pretty impressive, or a business that you own, I think you can use that. So, for example, if you owned a car dealership and you relied on your foreign national spouse to help you with the dealership, even, then that might be something that we could use.
Didn't we have a case similar to that?
Yes, we did. Yes, and of course I used that to the best of my ability to try to get that case approved. But it was one of the major factors that I used in my argument. Spiritual reasons as well. I also had a case where I had a client who was very involved with his church here in the United States, very involved, and it was documented. He'd been on missions trips, he was in the band at the church, and if he had had to relocate to the foreign national's home country, this, the Christian religion in this country just isn't represented, and he would have lost out on his community of his church community and being able to go to services on a regular basis.
That's pretty interesting. So the bottom line is you really have to look at every angle in one of these cases to see how many of these factors work in the client's favor.
Yes, and I can't tell you how important that initial brainstorming session is. And even after the brainstorming session, it doesn't stop there. As we're working on the case, we may think of other things to include in. And finally, of course, country conditions. Now, if you're from France, I'm not going to try to make a big argument that you're going to suffer. I mean, any argument you put here has got to pass a straight-face test. And also, but these are things that you see on the PowerPoint. These are all issues I'll look into depending on the foreign national's home country.
We want to thank everybody for attending this webinar. We hope you found it helpful. If you have any other questions related to this topic or any other immigration topic, please feel free to email amy@basham.com or myself, Murali, @basham.com, and we thank you for attending this webinar.